Welcome, everyone. This is class number 19 of the July 2024 Ibis Prep Florida Bar Exam Comprehensive Crash Course, and we are so excited today to be joined by Professor Marian. She is one of, if not the best, in the sense that she scored perfectly on WILLS when she took the Florida Bar, and all of her students that she has tutored individually have passed. So can't be any more flawless than that. And I think we're about to see why that's the case, because her presentation truly is phenomenal. And without any further ado, Marianne, you want to take it away?
Yeah, definitely. So thank you so much, Andrew, for the great introduction. And again, thank you everybody for having me. I've put together a presentation on Florida wills. And I know we were talking all a little bit before class, but basically Florida wills is one of the multiple choice topics in the first part of the exam, right? Day one, exam's going to start out with 3 essays, and then part 2 is the 100 multiple choice, right? So it's very likely that you can have some Florida wills multiple choice questions. And when they do test wills, they really like to test it. I've seen tests that a third of it is Florida wills. That's a lot, right? So it's worth knowing, it's worth learning it. And I have tried to put as much information as possible into these slides to help you guys get a good solid foundation on this, and just be ready to dive into the material, do some practice questions. So without further ado, I will go ahead and, oh no, is this working? There we go. Okay, cool. So when we think about Florida wills in general, it really encompasses not only wills and the distribution that takes place, and the formalities of the document. A lot of Florida wills topics and questions are also about the intestacy. Can you guys see my screen or no? Because I just got a message that you guys
Not
can't
yet,
see it.
but I'm sure we can in just a second. If you,
Okay. Right now it's just a white screen and it says intestacy on the probate estate.
so just, this happens to me sometimes. Just stop share and then reshare again and click it. It's a
Okay,
Zoom.
gotcha. All right, give me a
While you're
sec.
doing that, I'll try and tell a joke. Okay. So a man walks into a bar. He says, ouch. Cause like the bar, he like walked into it and then like, ouch, you know? Like he walked into the bar and like hit it. So there's physical pain because, oh, perfect. All right. The
Got
presentation.
it? Okay, cool. I think I pressed the Zoom and then I went back. So anyways,
I was getting
um,
tomatoes thrown at me, so thankfully
yeah.
wasn't.
All right, so we really want to kind of split wills up into two worlds, and that is intestacy world and testacy world. And yes, sometimes they do kind of combine and overlap and work with each other, but for the most part, we're really dealing with either an intestate estate or a testate estate. So to kind of kick it off, let's talk a little bit about intestacy and the probate estate. So what is intestacy? Intestacy is a legal term for when a person dies without a valid will in place, right? So this really happens in 3 scenarios. The first one, they just die without having executed a will, right? So decedent, that's the person who dies, pass away. And I'm going to be talking a lot about death just as a kind of to preface my whole presentation, because in wills, obviously someone's dying, a bunch of people are dying, it's horrible, but it just is what it is. So decedent is the person who died. So the first scenario is they died without having executed a valid will. The second one is they died and they revoked an executed will sometime before their death. And we'll kind of get into the revocation methods and how that affects everything. And the third situation is the decedent died and the executed will was held to be invalid for one reason or another, right? And we'll get into that too, and how a will could be found invalid even after somebody's death. And just take note that a person can also die partially intestate. So that can happen when the will doesn't include what's called a residuary clause. So a will has various clauses in it, right? And these clauses, for the most part, are clauses that are giving away a person's assets, right? They're distributing it to X, Y, and Z. Sometimes a will have what's called the residuary clause. And a residuary clause kind of just accounts for all the other stuff that we didn't talk about. So it's kind of all the leftover, right? So whatever assets I didn't devise to somebody in other clauses of my will, I may have a residuary taker in the residuary clause, and all the leftover things I didn't talk about will go to that person. If I don't have something like that in place, right? If a will doesn't have something like that in place, property that's not mentioned in those other clauses has to get distributed a different way. It has to get distributed through intestacy and the intestacy scheme, which we'll talk about right now. So you can die partially intestate. So when someone does die intestate, their estate goes through what's called the probate court, and the state's intestacy rules determine who's going to get these assets, right? So if you don't tell people how you want, and I shouldn't say, but if you do not write down in a valid will how you want your property to be distributed after death, the state is going to decide for you, meaning it doesn't really matter what you wanted. If you didn't leave your wishes in a validly executed document, then we're going to go to the default rules that Florida has in place, which is the intestacy scheme. So, as a general rule, even if you do have a will, there's no requirement that you have to leave any property to your family. However, the intestacy rules are going to favor family members. And again, remember, intestacy rules are going to apply only to probate property that is not disposed of by a will or otherwise. But they also won't apply to property that passes again by a will, or that's considered a non-probate asset. So there are some things that don't go through the probate estate at all. So some of the things that are not subject to probate are again, real or personal property validly disposed of by the testator's will, right? That's pretty obvious. Protected homestead property, right? We know that Florida has a huge homestead property protection in place. So something like that is not going to be considered probate property. Trusts with a named beneficiary, wrongful death proceeds, life insurance proceeds, property that you jointly own that has survivorship rights, payable on death accounts, retirement accounts, basically all of these things here, you may see a question that asks about one of these things. It will just go to the named person, right? So if any of you are familiar with, for example, a life insurance proceed or a 401k, you know you have to name a beneficiary, right? So that's not something that's going to go through the court and get determined like that, right? It's just going to go to the beneficiary for the most part. So let's talk about Florida's intestacy scheme, which is called the strict per stirpe system. So first of all, just to get a little vocabulary down, individuals that are entitled to take a share of a decedent's intestate estate are called the decedent's heirs, right? That's just the term that they like to use. Whereas opposed, if we're talking about a will, they're considered beneficiaries, not necessarily heirs. So a lot of times you can tell where a question is going just by the vocabulary that is used. So to actually take from someone who's passed away, a decedent, that individual has to actually survive the decedent, right? And that makes sense because one dead person is not going to give another dead person something, or a dead person can't take something from another dead person. Doesn't make any sense, right? So when we're talking about the strict per stirpe scheme, we're particularly interested in number one, the decedent's surviving spouse, and the decedent's descendants. So the decedent's descendants, just practically speaking, are going to be the children, the grandchildren, the great-grandchildren, right? Everyone who kind of comes after, for the most part, right? Those are your descendants, and then anybody on top of you is, you know, your ascendants, your ancestors, however you want to think about it. Think of the decedent as kind of being in the middle, and then either people are going down or they're going up. Sometimes people will go to the side, but we'll get to that. So the first person that we want to determine in this system is the surviving spouse. Why? Because they are the first taker under the Florida system, right? So you get a question, decedent dies, they don't have a will in place, but they have a surviving spouse. They're married at the time of death, right? That's the first thing that we want to take into account if there's a surviving spouse. And a couple of the ways that this can go is, all right, let's look at scenario one. There's a surviving spouse and there's no descendants, meaning no kids, and because no kids, no grandkids, etc., etc. If somebody dies, there's no will, and there's a surviving spouse, the surviving spouse will get 100% of the intestate estate. All right. Now, let's say we have a surviving spouse, but we also have kids, right? But these kids, these descendants, they are descendants that they share in common, right? So it would be, for example, husband passes away, has a surviving spouse, wife is still alive, and they had 3 kids, right? But these are kids that they share in common. Because those kids are shared in common, they are the surviving spouse is still going to take 100% of the intestate estate, right? So this is a scenario where there's a surviving spouse, there's shared children between the surviving spouse and the decedent, and there's no other kids, right? So that surviving spouse doesn't have any other kids that are not those kids, maybe from a prior marriage, right? That's not at play. And the decedent also doesn't have kids from somebody else, from a prior marriage, whatever it may be, right? The only descendants they both have are descendants that they share in common. So that's the second scenario. Surviving spouse is still going to get 100% of the intestate estate. Now, the third scenario is there's a surviving spouse and there are kids, there are descendants that are not descendants shared, right? There are some other kids here at play. So the decedent is survived by a spouse and other descendants. So it could be either descendants of the decedent or it could be descendants of the spouse. The key here is that you just want to look for any descendants that are not shared, right? If they have any shared, but there's also other ones at play, then this scenario comes into play too, right? So just look for if there are descendants that are not shared in common by the decedent and the surviving spouse. In that case, the surviving spouse is going to get 50% of the intestate estate, right? So not 100 anymore. Now it's half, now it's 50. And the other 50% is going to be split amongst the descendants. So let's talk a little bit more about the descendants. So they are the second takers under Florida law. Again, the surviving spouse is going to be considered the first taker. And that's going to refer, again, children, grandchildren, anyone below the decedent. And sometimes it's also referred, they're also referred to as issue. So just know that vocabulary in case they're just referring to descendants. So how you calculate the issues share, and again, that's just the descendants. You divide the estate according to the total number of children who survived the decedent, or they themselves left surviving issue. So this is really referring to the grandkids, right?
Marian, I don't
Yeah.
mean to interrupt, but there's a question in the chat. Someone said they're assuming the kids are minors. That's not really the case, right?
I'm sorry, can you repeat it? I heard something, the kids are minors.
Yeah, do the kids have to be minors to take, or it could just be any age
Oh,
kid?
no, they do not. It's going to be the same whether the kids are adults or children. Practically how it would work is if they get a share of an intestate estate, it would go into like an annuity or a college plan or a restricted bank account. But you don't need to know those things for the test, but practically that's how it works when that happens in real life. So again, when you calculate the issue's share, right, you're going down to the descendants. You have to divide the estate according to the total number of children who survived the decedent, or leave surviving issue. And we'll do an example because I know that it sounds kind of like, what do you mean? Like that makes no sense. But just know that that's the first step. And the second step is that you divide by representation. So what that really means is that children can represent their deceased parent. And I kind of did a little example, and I had to draw this, so that's why it doesn't look super nice and neat like the rest of the PowerPoint. But this is my beautiful art. So let's do just example one, right? A died, leaving behind 3 children, B, C, and D. There is no surviving spouse, right? So we know that the intestate estate is going to be divided somehow amongst B, C, and D, right? Because they are descendants and they are the second takers under the Florida intestacy scheme. So in this case, this one's pretty simple, right? How is the estate going to be distributed? Well, we're just going to go down and divide it by how many children survived the decedent. So in this case, it's 3, right? So we're literally just going to go 1/3, 1/3, 1/3. So 1/3 of the intestate estate is going to go to B, 1/3 is going to go to C, and 1/3 is going to go to D, right? Simple enough. So example 2 kind of represents a little bit how it would go when maybe one of the children are predeceased. Okay, so same thing, A died and they do not have a surviving spouse. A had 3 children, B, C, and D. B and C survived A, but D predeceased A, right? And we know that a dead person cannot take from another dead person. If you died before me, it doesn't make sense that you get anything from me. I mean, you're not here. What are you going to take? But what else do we know? We know that D has 2 children, E and F. So how will the estate be distributed here? So again, when we go back to step 1, really what it's saying is that you divide based among how many children survived the decedent or left surviving issue. So what does that mean? We know B and C are alive. We know that they're going to get a share. That's not really a problem there. But when we get to D, he didn't survive A. However, he left surviving issue, right? Issue again would refer to descendants, and E and F are A's grandchildren, right? Because D is the son or the daughter, whatever it may be. So we're still going to take D into account here, because even though he died, he did leave surviving issue. So we're going to split it amongst 3, okay? Because we're going to take D's share into account, and then we can further distribute that. So it's going to go 1/3 to B, 1/3 to C, 1/3 through D, but then obviously we have to split up that third because E and F can't just get 1/3. We have to split that in half between the both of them. So what ends up happening is 1/3, 1/3, and this 1/3 will go down and be 1/6 and 1/6. And that's how we get to that answer. Does that kind of make sense to everybody? If somebody doesn't understand that, feel free to just shout it out. The more of these you do, the easier it gets. A lot of people have issues when they first start to learn the per-stirpe system because it is a little confusing, but I like to think of it as a game, right? When you first start playing a game, you don't really know the rules. But once you learn the rules and you play a few games, you start to actually get good at it and like it and enjoy it. And that's how I feel about doing these kinds of questions. And I would recommend when you get these type of questions to kind of draw it out like I did here. Again, these slides will be available to you guys. So if you can look at everything that I'm talking about today. But this is usually how the graphs are drawn in these type of questions, because it's a lot easier when you have it visualized like this instead of trying to do it in your head. But honestly, if you do enough of them, I promise that you will start to like it because it'll start to feel like a game. And at some point, you'll probably even be able to do it in your head. So we've talked about the surviving spouse being the first taker. We've talked about descendants being the second taker, and we've kind of touched on some scenarios where both are involved. So let's say that somebody dies and they don't have a surviving spouse and they don't have descendants, right? And you can even think of it as somebody who dies, really young. They didn't get married, they didn't have kids. So the third taker under the Florida intestacy scheme are the parents. So again, if a decedent is not survived by either a spouse or descendants, the decedent's parents are next in priority. So if both parents survive, simple enough, half and half. If only one parent survives, then they'll just take the entire estate. And just know that the term parent, at least here, it does not include step parents or foster parents. It will include legally adoptive parents, right? But not step parents and not foster parents. So just continuing to go down the line, you have no surviving spouse, no descendants, and no parents, right? But you have some siblings. Those are going to be next in line. So again, decedent has no surviving spouse, descendants, parents, decedent's brothers and sisters divide the estate, right? Now let's say that they have a sibling, that sibling predeceased the decedent, but they left behind some kids, meaning it's going to be decedent's nieces, nephews, right? If there's nieces and nephews there, then they can absorb their parents' share, right? It'll be equally divided amongst them. And Florida loves to test this for some reason. I don't know why. It's so weird, low-key, and it's old school, but there are different rules for half siblings and whole blood siblings, right? So whole blood siblings, same mom, same dad. Half sibling, right? You only have one parent in common. So the general rule is that half blood siblings only take half as much as a full blood sibling. Again, it's a weird rule, and we'll talk a little bit more about it in a few slides, but definitely something to know because it's a super easy question to get right if it comes up. So again, this is just going down the line. If the decedent is not survived by any of the above mentioned categories, Florida will divide the estate equally between what's called the maternal and the paternal kindred. So that covers the decedent's grandparents and their descendants, right? So think aunts, uncles, cousins. If none of those people are alive, we have two more options left, really. So the second to last one is the kindred of the last deceased spouse. So if the decedent is survived by none of the individuals above that we've talked about before previously, there's one last group of potential heirs. If that decedent was preceded in death by a spouse, the property goes to the kindred of that deceased spouse. So basically, we're going to look at who is left on the side of their last deceased spouse. If there's anybody there at all, right? Let's say that their last deceased spouse had a child, even if it's not their own child, right? At this point, we're just trying to give it to anybody because this person had nobody. We'll give it to them. And if there's no one there at that point, then it will go to the state of Florida. All right. And even when it does go to the state of Florida, qualified heirs still have the chance to proclaim that property that passed to the state of Florida for, 10 years, within 10 years of it passing. So it really actually does take a lot of steps before the state just goes on and take your property, right? We try to give it to basically everybody. But the general rule is if you have a surviving spouse, most likely it's going to go just to them. And then you start going down, right? If you have nobody down, then you have to go up. If you have nobody up, then you're gonna go to the sides, right? And when I say the sides, I mean your siblings, because that's how I kind of tend to think of things. Your siblings are beside you, your parents, your ancestors are above you, your descendants are below you. So that's the strict per stirpe system. Best thing you could do to get a hang of it is just do a bunch of questions, do the little charts, and you'll get the hang of it sooner rather than later if you practice. So moving on, I want to talk about some of the special circumstances when we're dealing with an intestate estate. And some of those special circumstances are adoption, out of wedlock births, afterborn children, and half-blood relationships. And I only mention this because it is tested in Florida. I tried to keep all of this limited to things I know that they test. So let's talk about adoption. And I mentioned previously that adoptive parents will be able to share in the intestacy scheme. And that's because when it comes to a legal adoption, Florida is going to recognize that as if it was a natural blood relationship, meaning upon being adopted, a child is deemed to be a descendant of the adopting parent, right? They're not going to be treated any differently. Generally, the adopted child can no longer inherit from or through the birth parents, right? Their natural birth parents. And that's because little family law kind of knowledge in here, in order to adopt, you know, you have to break that initial relationship, right? That initial parentage and create a new one. So for that reason, usually adopted kids are not going to have that legal relationship, that legal inheritance, right, through their birth parents. And that goes, the same goes for the birth parents, right? The family of the birth parents can no longer inherit from or through that child. There are some exceptions. There's three exceptions, but I kind of bolded the one that I've noticed is tested over and over again when it is tested. And that is that a child may inherit from a deceased birth parent's family, although the child has been adopted by the surviving parent's new spouse, as long as the new marriage and the adoption occurred after the birth parent's death. So I know that that's a lot. So just to break it down and kind of give you an example, that would be two people are married, they have a child, and one of those parents dies, right? They die, the surviving parent gets remarried sometime in the future, and the person they got remarried to legally adopts that child, right? In that case, it's not necessarily that they gave the child up for adoption in any way. It's just that one of the parents passed away and somebody just took on the role, right? We're not going to penalize things that happen in that way. So the child will still be able to inherit um from the family of the dead parent, if that makes sense. So that's usually the one that is tested the most. But just read through the exceptions and have a sort of understanding about them, because if adoption is tested, it will probably be one of the exceptions that they test. Um, the next kind of special circumstance is children born out of wedlock. Again, you know, Florida's a little bit old school with these things. So this is focused on the need to prove paternity. So a non-marital child, a child born and the parents aren't married at the time it's born, has inheritance rights with respect to the mother, right? There's kind of no need to prove that a child is the child of the mother because the mother gives birth to the child, right? But sometimes the father, it's not that easy to determine. So a child born out of wedlock would be considered the descendant of the father if the birth parents entered into a marriage ceremony, even if the marriage is void, either before or after the child's birth, not a big deal. A child can also inherit from the father and the father's family if paternity is established either in court or by the father's written acknowledgement, right? As long as the evidence is clear, strong, and equivocal. So just look out to see if those factors are at play. After born children, really not too tested, but just a general kind of note. After born children, they're going to be children conceived prior to, but born after somebody's death. So generally, somebody has to be alive, right, when the decedent dies in order to inherit. But if the child is in gestation at the time of the decedent's death, they'll be taken into account. Not super tested, not huge to know, but just in case, it's a simple little rule that you can have in your mind in case you do get a question like that. Half-blood siblings, they really do like to test, and it's not a hard concept. So again, an easy little rule where you can just get that question right and move on. So half-blood relatives are treated differently than whole-blood relatives. And again, this is going to be really in a scenario where you're talking about your siblings, right? So in this scenario, there's no surviving spouse, there's no kids, there's no, grandkids, mom and dad are dead, you're in sibling world, right? That's really the only time that this is considered. So it's a really, really limited scenario. Under Florida statute, each half-blood heir receives only half as much as a whole-blood heir, right? Obviously, if only half-blood family members survive, the shares are equal, right? But that's because there's nobody else to give it to. So there's a little kind of trick here as to how to calculate it. You give each whole blood sibling a 2, right? It's just a little math, but it's nothing crazy. You give each whole blood sibling a 2, each half blood sibling a 1, and then you add them up. That's the denominator, and then you would kind of just compute accordingly, like that. So just do a few examples with that formula. It's really easy. It's not bad at all. And you'll be fine for the half blood sibling questions. So that's kind of the rundown of the intestate estate. Even though the subject is called Florida wills, a lot of the questions have to do with intestacy. So knowing that intestate scheme and the little things that could limit it, as far as their distribution, knowing that order and who gets what when different people are at play is really, really important. If you don't know that, it's gonna be a little bit difficult for you to get a good score on that section. So I would highly recommend just becoming comfortable with the strict per stirpe scheme, because it will help you tremendously. Because again, we talked in the beginning about how somebody can die partially intestate. So even if you are intestate world where someone dies with a will, there may still be something that you're going to have to apply this scheme to. So just know it really well, because there's just way too many scenarios where it comes up in a question. But moving on, let's talk a little bit about the testate estate, which is, of course, just as important. So a testate estate is an estate where the deceased left a valid will that specifies how their assets are to be distributed after their death, right? So you're going to see the words testator or testatrix. I'm not even sure if that's really how you say that, but that will just be referring to the decedent who executed the will, right? So a lot of the questions when it comes to wills also focuses on the execution of the will itself. And this is because Florida requires strict compliance with the execution requirements for wills. So some of the requirements, and let me just, okay. So first of all, it has to be in writing, right? Whether it's handwritten, whether it's typed and printed, doesn't really matter. It just has to be a written document, all right? The testator has to sign the will. If you're going to use a proxy, right, somebody in your place, you can do that. A proxy can sign the testator's name on their behalf, but it has to be in the actual physical presence of the testator, right? So they can't take that document elsewhere, sign it, and bring it back. They have to be physically together at the time when the proxy signs on behalf of the testator. The testator has to sign at the end of the will, right? So that's going to be after all of the provisions, after all of the clauses. Just think practically, right? Where would you sign a document? You're not going to sign a document in the middle of the page. You're not going to sign it at the top, right? You're going to sign it at the bottom. You want it to be the very last thing. You want it to be the date and signature, right? So just make sure that there are no provisions below that signature, because that's going to be a basis for contesting the will. And then probably the most important part is that there must be two witnesses, and these witnesses must sign the will, and they have to sign it in the presence of the testator and in the presence of each other. Right, that's probably the most important element. There's two presence tests used throughout the United States. It's unclear which one Florida follows, but I think it's just safer to go with line of vision, just based on the types of questions that I've seen come up on these exams. So the line of vision test, basically what that means, just broken down, is that you are able to see the person actually sign, right? They are in your line of vision. You are there. Conscious presence is a little bit more loose, right? You can have a conscious presence that someone is there, but that doesn't necessarily mean you're in your line of vision, right? Like right now, I know that my husband is on his computer in the living room. I'm consciously aware that he is present there, but he's not in my line of vision. I'm in my office, right? So think about it like that. When you get these scenarios, you really have to think about where these people are. I would follow the line of vision test. I would make sure that these two witnesses are in the same exact room, like next to each other, across from each other. They can see each other while each one signs the document. All right. That's really, really tested. So just know that, be really, really strict with the rules. And just a few notes, in Florida, there is no requirement that the witnesses to the will be disinterested persons. What does that mean? You can be a witness to a will that you're getting something from, that you're getting money, that you're getting property from. Not a big deal. Florida also allows minors to be witnesses, weird enough. But there you go. Another note, there's no requirement that the will itself be notarized. So whether or not it's notarized doesn't really matter, the will itself. Florida does not recognize what's called holographic wills, which is unattested wills. Basically, that just means wills that are not signed, right? They're not attested to. There's no witness signatures on it. Or oral wills. Again, one of the requirements is that it be written. So you can't just tell somebody what you want. You actually have to write it down and follow all these formalities. And although not a requirement, most wills do name a personal representative who is in charge of the administration of the estate. And a personal representative will be appointed in the case that it is an intestate estate or a testate estate, because whether or not you die without a will, you still have to go through probate court, right? The will still has to be probated if you have a will. And if you don't have a will, you kind of got to deal with all of your assets. You don't really need to know all the specifics of that. But I do want you guys to just make a note to get familiar with the requirements for a personal representative and what they do. It's not a hard concept at all, but I didn't put it in these slides. So I just want all of you to make a note to know that. Because again, easy question that I know you guys can get right. So in order to admit a will to the probate court, the court must ensure that the will was executed with the formalities that we just talked about, right? All the requirements that we just talked about. So there's going to be two options to be able to do so. One of them is going to be a sworn testimony or oath of one of the witnesses to the will. Or the second, much easier way, is a self-proof affidavit is presented, and that permits the will to be admitted to the probate court without any further proof. So you're not going to need testimony. You're not going to need to call up these witnesses and tell them like, hey, I need you to do this. I need you to do an affidavit. I need you to go to the court, right? If the will has what's called a self-proof affidavit, then you're good. It's going to be probated with no problem. And a self-proof affidavit is basically just, it's a document, it's a written document, and it's sworn testimony that the execution of the will complied with Florida law. So it is signed by the testator and it is signed by two witnesses. Now, it doesn't necessarily have to be completed at the same time as the will, right? It can be completed at the same time, but it can also be completed after. It just has to be executed with the same formalities. So we know the testator has to sign it and two witnesses. Now, they can be the witnesses to the will, but they don't necessarily have to be, right? We're just looking for two witnesses. And the witness cannot be the notary to the affidavit, because next requirement for self-proof affidavit is that it does have to be notarized. So will, you're good if it's not notarized. Self-proof affidavit does have to be notarized. So that's really all you need to know about that. Another issue that they like to test is testamentary capacity and intent. And I know this slide looks a little insane, but really when we're talking about testamentary capacity and intent, we're really just looking for the ability of the testator to understand the nature and extent of the property he is disposing and who it's going to, right? So basically that's what you want to look out for. Do they know the extent of the things that they own, and do they know what they're doing when they're disposing of it, right? And testamentary intent, basically, here are the requirements, right? Age, got to be at least 18 years old. Sound mind, you have to be of sound mind, can't be incapacitated for the most part. You really just have to intend to make a will. So I know they sound a little bit broad, but they're concepts that are not that difficult to understand. I think that the questions that are based around testing those concepts, it's very easy to see when those things are missing. So they'll be easy to spot in a question. Another thing that we need to talk about for sure is amending and revoking a will. Because again, this is definitely something that they really like to test. I'm sure that, if you guys took wills in law school, or if you've watched, maybe movies or TV shows where there's a will in place, you know that a lot of times in real life as well, someone will make one will, and then they'll make another will, and then they'll make another will and another will, right? People are changing how they want their property to be disposed of all the time, right? They get into fights with their family. They have another kid, they have another spouse, they get married, whatever it may be, right? People are changing these documents all the time. So amendment and revocation, there are two means by which a testator can revoke a will or a codicil. And we didn't go over what a codicil is, but a codicil is basically just a separate writing which seeks to amend something about an earlier will. So a codicil is just its own separate document, but it's going to be referencing and making some sort of amendment to an earlier will, right? And this document needs to be executed with the same formalities as a will. So that means testamentary capacity, testamentary intent, sign it, two witnesses, all that kind of stuff. All right, but that's really all a codicil is: separate written document amending some provision or amending something that was stated in a will. And what that would really mean is, let's say I wrote a will in 2023 where I left I left $50,000. I don't have $50,000. I wish I did, but let's say I had a will, 2023 will, I'm leaving $50,000 to my friend Melanie, right? 2024, me and Melanie get into a huge fight. I don't want to leave her $50,000 anymore, but I also don't want to write a whole new will, right? I'm just going to write a codicil. I'm going to make sure that that codicil is executed with the same formalities that a will would be executed with. And I'm going to say, my 2023 will, which references the $50,000 devise to my friend Melanie, is hereby amended, and the $50,000 is now going to my friend Natalie, right? Sometimes it's not too clear cut like that, but that's the general idea, right? You're amending something about an earlier will. So again, there's two means by which you can just completely revoke either a will or a codicil, right? So you're not amending, you're just revoking. And that is by a subsequent writing or a physical act. So both methods of revocation are going to require testamentary intent and testamentary capacity. So what does that mean? You're of age, you're of sound mind, you know what you're doing, and you know how it's going to affect how the property is being passed, right? Basically, you know what you're doing. Express revocation by subsequent writing. So this is going to be accomplished by proper execution of either a subsequent will or a codicil that expressly revokes the prior will. So if you're seeking to revoke a will, right? I want to revoke the 2023 will that we had mentioned earlier. I just want to revoke it completely. I don't even want to amend it. I just want to revoke it. Really, I can do that one of two ways as far as writing. I can either just write a whole new will, and now that will is the one that's going to be probated, right? We always go with the later will. If I write something in 2023 and then I write something in 2024, the 2024 one is the one that's going to go, right? So in the 2024 will, I'm most likely going to say, I hereby expressly revoke all other prior wills and intend to make this my last will and testament, right? There'll be some language sort of stating that. So that sort of language and that subsequent writing, again, as long as it's has all the formalities that it needs to have, it's going to revoke all prior wills before that. All right. And you could do that with a codicil too. So if I don't want to write a whole new will to revoke my earlier will, I can just write a codicil and say, I hereby revoke all my prior wills, period, right? I don't need to state anything else. So that's basically how you would entirely revoke a prior document. Okay, so revocation by inconsistent subsequent will or codicil. So sometimes you're not going to get a fact pattern where the subsequent writing has something, really simple, really given, such as, I expressly revoke all prior wills. You're not going to have that sometimes. Sometimes what you're going to have is a 2023 will that says one thing, and then a 2024 will that says something completely different, right? Maybe in that will, there's no express revocation of that prior will, but the general rule is you're just going to go with the later will, right? You have two documents that are inconsistent with each other. That later document doesn't expressly revoke the prior document, but the general rule is just go with the later document. It was executed after, so it was likely the testator's intent for that one to be probated. Again, always looking out that all the requirements for valid execution are in that later document. So that's revocation by subsequent writing. And revocation by act is the second way that you can revoke, a will or a codicil. So a will or a codicil that is revoked by a physical act is completely revoked, right? Meaning a testator may not use a physical act to amend a will or codicil or revoke only a part of the will or codicil. So if you get a scenario where someone tears it up, right, they burn it, something like that, that they're just completely by physical act destroying this will, that's going to be, a complete and total revocation by act. There is no partial revocation. So you can't just break off one page and that will be, taken as a complete revocation, right? Now it's up for debate. Now we're going to have some issues, right? You can't do a partial revocation. You can't just be like, I don't like the divisors I made on this page, I'm just going to rip it out, but everything else stays the same, right? You can't do that. You can't partially revoke something. If you wanted to just make an amendment, then you should have just gone through the ways to make an amendment. And if you wanted to revoke it completely, then you should have done something that was more clear, or something that is allowed by the law. So no partial revocation by physical act. Just remember that. And the compliance with the revocation rules is really, really strict in Florida. So just make sure you know them well. Just to get into this a little bit, I want to try and make it as simple as possible to understand, because this topic can get a little bit, it could get a little bit confusing sometimes. But revival or republication of a revoked will or codicil. So sometimes this is really going to be a scenario where they haven't necessarily been any prior things that have been revoked, haven't really been revoked due to a physical act, right? Because usually the physical act, they're completely destroyed. So practically, the scenario is that these are all still intact documents. They were just revoked at some point, right? Wills or codicils. So a codicil will revive a revoked will. So let's say that a testator's subsequent will revokes the testator's previous will, right? My 2024 will revoked my 2023 will. So that previous will is going to remain revoked even if I later revoke the 2024 will, right? My destruction of a later will not by itself revive any of the prior wills, right? Once there has been that initial revocation of the will, there's going to have to be a little bit something more for that to be revived, if that's what the testator wants to do. All right. But by itself, it's not going to be an automatic revival. So let's say we're in a scenario where a testator executed a codicil to revoke part of a will or part of a codicil, or whatever it may be. If the testator revokes that later codicil, it's going to be presumed that the testator intended to reinstate whatever portions were revoked by that codicil. So just to go back to the example that we were talking about, if I have a will, a 2023 will, I'm giving $50,000 to my friend Melanie. I executed that 2024 codicil, stating that I don't want it to go to Melanie, I want it to go to Natalie, right? I revoke that codicil, right? I tear it up, because you can revoke codicils the same way you revoke wills. I tear it up. The presumption is that now the entire will is going to be fine, right? Because I'm really just revoking that one amendment that I made, right? So I didn't do anything to the will itself. Will is still good. If I revoke a will, and this is just a separate scenario now, if I revoke a will, I'm also revoking all codicils to that will, right? So if I have, same thing, I have a 2023 will, and then I had a 2024 codicil, right? That's the scenario. 2023 will, 2024 codicil. That 2024 codicil made that amend to my 2023 will. Now, let's say I burn my 2023 will, right? That 2024 codicil was part of the 2023 will, right? That 2024 codicil doesn't really stand on its own, right? It doesn't make sense without the context of the will. So if the codicil, again, it's used to revoke or amend just a part of an earlier document. If I revoke that earlier document, then it would only make sense for that later document to be revoked too. And I think that is pretty much what you need to know about those things. Again, it can be a little bit tricky, but when you get these types of scenarios, just try to break it down as much as possible, and just try to keep track of everything that's going on. A lot of the wills questions are very, very fact specific. So just really, really focus on what's going on, try to make charts, try to understand dates. And remember that once a will is revoked by another will, just by itself, that doesn't necessarily mean that those prior wills are going to be revived. 90% of the time, heck, not even 90, like 98% of the time, once they're revoked, I don't even want you guys to think about that anymore. They're done. All right. Lost or destroyed wills. So in the case that the original can't be located, there are certain steps that somebody has to take. It's not super, super important, but it's a very short slide, so you guys can definitely go back to it. I don't think that we super need to go over it right now. I do want to talk though about the types of devises that are made in the wills. So a devise is just a disposition of the testator's real or personal property. And there's specific types of devises, right? There's 4 types of devises. And this can come into play when we're thinking about abatement, which we're going to get to next. But we first have to kind of determine what type of devise it is. So a specific devise, it's going to be a devise of property, which is particularly designated, okay? So it's going to be really, really specific. My real property, Green Acre, located at 321 Main Street, Fort Lauderdale, Florida, right? That is a very, very specific thing. You know exactly what I'm talking about. You know exactly where it's located. You know exactly what I mean. You know exactly what I'm trying to devise to you, right? Or all of the jewelry that I own at the time of my death, right? And even further, even more specific than that, you can be like, my yellow diamond ring with the gold plating, right? Just something super, super specific. A demonstrative devise, it's going to be a devise of a fixed amount. So this is really going to refer to cash, right? It's going to refer to money. A devise of a fixed amount payable first from a particular property, and second from general assets that are insufficient, if it's insufficient. So what does that mean? It's going to look something like this, right? This is literally what it's going to say. $100,000 to X, payable first from my account at First National Bank, and to the extent that the account is insufficient, from the general assets of my estate, right? That's what a demonstrative devise looks like. So again, really easy to spot because it has to be worded this way. The third one is a general devise. So it's not specific, it's not demonstrative. It really just indicates a particular amount or quantity to be received. So if we look at this, it says $50,000 to my nephew Jim, right? It's not, we know it's not a specific devise, right? And we also know it's not a demonstrative devise because we don't know where the funds are coming from. It just says $50,000, right? It's very generalized. And then the last one is the residuary. And we talked about that a little bit before. And what that will look like, it will really just say this: I devise all the rest, residue, and remainder of my estate to whatever. This one says my children. That's the example, right? That's basically what it will say. And again, that's really just the leftovers. And as far as priority, this is the way it's put out here, 1, 2, 3, 4, that really is priority. And if you think about it logically, the more specific you are with something, you probably really, really wanted like that person to have this because you were so specific about it, right? So that'll be the level of priority when we consider abatement. So abatement is going to come into play if the estate of the decedent basically it's inadequate to pay all the claims, all the expenses, all the devises that they're making. So when that happens, right, we have to start cutting some things off, right? Who are we going to take from? How are we going to make who needs to be whole whole? So the order of abatement is going to be as follows. If there's any property that's passing through intestacy, so anything that wasn't accounted for in the will, we'll take that into account first, right? And usually what's happening in these abatement scenarios is the estate owes money, right? So somebody dies with debt, right? And that debt needs to be repaid. If the estate does not have sufficient money, but there's devises, there's intestacy property, right? We are going to need to take some of that to try to satisfy these debts. And we'll talk about who gets priority so that you know who does come into play and who doesn't come into play in abatement. So first thing we're going to consider is, well, okay, maybe we shouldn't have to touch anybody's devices, right? Maybe there's intestate property, right? That's kind of not to priority. We'll touch that. No intestate property or intestate property still isn't enough to, make these creditors whole or whoever it may be. All right, well, what's the residuary, right? Is there any devices to the residuary? Because again, order of priority, whoever's getting the leftovers, right? We're going to take from them first, should we need to. And again, the order is just if it continues to be inadequate, not enough, we would move on to the general devices, the demonstrative devices, and the specific devices. I think that for the purposes of the bar exam, I don't think that you need to get super into the formula of it. I think you just need to know what the hierarchy is for the abatement process, right? Like who would get picked on first. And this is a little formula as to how to do it. So you guys will have it and you can use it to kind of practice with any abatement questions. But what you really need to know is the order in which it could happen. And also who are these creditors, right? So we have a priority of expenses and obligations. And this is the order of priority here. So the first people who need to get paid, right, are any expenses relating to estate administration. What does that really mean? Lawyers, right? Lawyers draft these things, so they're always going to protect themselves, and that's going to be consistent throughout any subject that kind of touches on any of these things. Florida rules of professionalism, a lot of the times you're going to see lawyers putting themselves first, right? So that's going to be class 1. Class 2 is going to be the decedent's funeral expenses. They do have a cap at $6K. Class 3 is going to be debts and taxes that have preference under medical law. So that's going to be things like Medicaid, unpaid court costs, unpaid taxes, things like that. Class 4, expenses related to the decedent's last 60 days of their final illness. Then we have a family allowance, which is capped at $18K, court-ordered child support arrearages, business debts, and then finally all other claims, right? So a lot of the times, practically class 1 and class 2 get paid, right? And like class 3 maybe if that's at play. But all of these other classes, usually just practically they're probably not going to get paid, right? Especially if it's a small estate. So I think for sure, as far as abatement, just know the order of priority there, and then the order of priority for the creditors. Okay, pretermitted spouses and children. So a pretermitted spouse, definitely something that you guys need to know. That's when a spouse receives absolutely nothing in the will, right? So you're married, you write a will, you leave absolutely everything to your best friend, right? And your spouse, you die and your spouse is pissed because they're like, what the heck? Like, she didn't leave me absolutely anything. He didn't leave me absolutely anything. You know what? I'm going to contest this will, and I'm going to say that I'm a pretermitted spouse, right? And again, that's when a spouse receives nothing in the will. So a pretermitted spouse, they have certain rights, right? They receive the share of the decedent's probate estate that they would have received if the decedent had died intestate, right? So what does that mean? Because what do we know about surviving spouses? Surviving spouses, for the most part, usually get 100% of the probate estate, right? Of the intestate probate estate. So that means that if you're in a situation where someone dies with a will, they left everything to their best friend, and they have a surviving spouse, and this surviving spouse wants to come forth with her rights as a pretermitted spouse, that friend that you left everything to in the will could end up with nothing, and your spouse gets 100% of it, right? Again, it obviously depends on who's there. Are there descendants, right? Which is why it's so important to know the intestacy scheme, because even in a scenario where there is a will, things could change up. So yeah, pretermitted spouse, they'll be entitled to whatever they would have gotten under intestacy. So super important. Sometimes we also have pretermitted children, and there are some exceptions about pretermitted spouse. If they are not in the last slide, I'll add them and have this re-uploaded so that you guys know them. Or they may just be in one of the outlines here on IBIS. But pretermitted children, also a thing. So pretermitted children, they are usually just children who are not accounted for in the will. So a surviving child, if they're omitted from the will, they can claim an amount equal to their intestate share, right? But there are certain requirements in order for that child to be eligible. So the omitted child must have been born or adopted, legally adopted, after the will was executed, right? So if you have a scenario where the decedent leaves a will in place, and they have 3 kids and they only left stuff to 2 of their kids, third kid gets nothing, and that third kid was alive when they wrote that will, that's it. One of the requirements is missing. They cannot claim that they are a pretermitted child. So that's requirement number 1. Requirement number 2 is that the child must have not received their share as an advancement. So sometimes, let's say that the will is going to call for $10,000 to go to each kid, right? But before the will is even executed, dad gives that third child his $10,000, and he's like, hey, look, this is for an advancement. I was going to give you this as part of the will, but I'm just going to give it to you now, right? It's serving as an advancement for something that would have been passed by the will in the first place. So in that scenario, if that's what's happening, they also can't claim that they're a pretermitted child, right? And even when these requirements are met, sometimes the child can't benefit anyway. So if it appears from the will that the omission was intentional, so if there was some sort of writing in the will that says, I intentionally left out my third son, Eric, from this will, then that's going to be, pretty clear evidence that this person didn't want them to partake. And a quick little side note on that, that is very different than somebody straight out putting in their will that they're disinheriting somebody. Because in Florida, you're not allowed to do that. So you can put, it is my intention for XYZ to not receive under this will, that's fine. But you can't outright say, like, I disinherit my son because he's lazy and he treated me really bad in my old age. So he can't get anything. You can't do something like that, right? That's not going to be allowed in Florida. But if there's some sort of writing in a different way where it's clear that the omission was intentional, you can't really say that you're a pretermitted child. All right, so lapse and anti-lapse, and we are nearing towards the end. I think this is my last slide. So I want to talk just really quickly about lapse and anti-lapse. So the Florida Wills anti-lapse statute protects grandparents of the decedent and those grandparents' lineal descendants against the common law lapse rule. So the common law lapse rule states that a testamentary gift, right, a testamentary devise, will be deemed to have lapsed if the beneficiary of that devise predeceased the testator, right? So you make a will, you say, $25,000 to X. But before that will is probated at the time of, shortly after the time of your death, X had predeceased you and you never changed your will. That will's valid. X, how is X going to get, the money if they're dead? So that's what would happen at common law. They would just say, well, it lapsed, right? And they would deal with it another way. A resulting trust arises in favor of the testator's estate. It gets really complicated. Florida doesn't do that, right? Florida has an anti-lapse statute in place where if a gift is protected under that statute, the property is going to be distributed anyway. So the first thing that we have to determine is, well, the person who it was supposed to be distributed to, right? Is that person either the grandparent of the testator, right? Or is it a descendant of the grandparent of the testator, right? So you're kind of looking for that relationship, and that's really all you need. If you can establish that relationship, um, then you know that the anti-lapse statute is going to kick in, and what's going to happen is that either the grandparent or the descendant of the grandparent is going to be able to kind of absorb that gift. And again, it's really not too difficult of a concept once you do some questions on it. Just look for that initial relationship. The person who predeceased the testator that was supposed to get this thing under the will. Are they the testator's grandparent, or are they a lineal descendant of the testator's grandparent? Meaning, if this person that was supposed to take was the testator's best friend, right? Anti-lapse is not going, it's not going to work there, right? Because first of all, it's not the grandparent, and we know it's not a lineal descendant of the grandparent, right? Same thing with if it was your spouse, right? You left something to your spouse and your spouse predeceased you. Your spouse, however close you may have been to your spouse, they're not your grandparent or a lineal descendant of your grandparent. So anti-lapse is not going to be able to apply there. So as long as you can determine that initial relationship, the rest kind of becomes easy. If the relationship is there, they'll take, right, in place of that. And if the relationship is not there, then it's just gonna go through either the residuary or intestacy. All right, either or. If there's a residuary clause, it'll go into the residuary and be absorbed by the residuary taker. If there's no residuary taker, it'll just go through intestacy, right? Because it'll be something that wasn't validly disposed of by the will. Why wasn't it validly disposed of? Because the person is predeceased and the anti-lapse statute will not apply, and there's no residuary taker. So again, I think with wills, everything is really fact specific. So when you're doing these questions, just try to kind of slow down, understand what is happening in the scenario, take everything step by step. It may take you a little bit longer at first, but when you get the hang of the rules and the way that this subject kind of works and the way that the law works around it, it will get a lot easier. I feel like wills is just one of those subjects where it's overwhelming at first, and then it becomes like everyone's favorite subject. I feel like every time I say this, everyone always comes back and they're like, you're right. Now I can't wait to get a wills question because I know that I can knock it out of the park. And I know that if you guys put your mind to it, you guys will definitely knock them out of the park and get a super good score. Again, if it is tested, it's tested heavily. So if you get these things down, there's no way you're not passing Florida multiple choice. So I tried to go through as much as possible. I know I've been talking for like a really long time, but there are still some more wills topics that are pretty important, definitely worth doing a little bit of, deep diving into, doing some questions on them. And I've kind of just set them out here. Try to review those things if you can, because again, I don't think that these things are too crazy, and they tend to be the easier questions. I think the things we went through today are kind of the harder subtopics. So if you guys have any questions or anything like that, again, you could put in the chat, you can just ask them, but feel free to email me. This is my information, this is my email. You can email me with any questions you may have. If you need help just with anything wills related, whether it be outlining questions that you have done and don't understand, or just questions about what I've talked about today, that's my email. I'll kind of just leave it up so that you guys can copy it or whatever. But yeah, I hope you guys learned something today. And I hope that if you weren't too keen on wills when you first walked in here today, I hope that you're a little bit more comfortable with it now, and that you guys are ready to kind of tackle this subject, do some questions, and get them all right on the bar exam. Because if I can do it, then you can do it too. And that's it. I'm done.
Thank you so much. That was absolutely amazing. I'm going to go ahead and stop this recording.